Hi, everybody. I'm Nick Brooks, and welcome to the Nick Brooks Podcast. What if Texas could slap a 100% tariff on people moving from New York City as a result of Zohran Mamdani's election? Well, we're going to go over that today in today's episode, and we're going to discuss it from a legal perspective. First things first, let's go ahead and put up the tweet by Governor Abbott so he doesn't accuse us of lying about his statements. So, here is on X. He wrote, after the polls close tomorrow night, I will impose a 100% tariff on anyone moving to Texas from New York City. Okay, well, you heard it there first. That's his exact statement, and it's not hearsay, so we're going to go ahead and use this statement against him. But before we do, let's go ahead and jump into the relevant factual background. Obviously, you saw the tweet. It was made the night before the election. He publicly announced, and whether he was serious or joking, because there's some commentary that he wasn't so serious and that it was joking. That he had an intent to impose a 100% tariff on people moving from New York City to Texas after the New York City mayoral election. He basically cites concern over migration from blue states and shifting demographics, I suppose. However, such exclusionary ideas are not, they've not only arose in Texas, they have a historic pattern within this country. In the 1930s and 40s, California faced a Dust Bowl influx where hundreds of thousands of Okies, which were poor, mostly white migrant families from the rural South and the Midwest, were fleeing environmental disaster. There had been droughts and dust storms and things of that nature, which caused a lot of economic harm. And so these, families were seeking refuge in states with more wealth, such as California. However, California had a very strong reaction. Let's just go ahead and go over this. Well, law enforcement set up these, quote, bum blockades on the border to intercept and turn away any indigent migrants. The legislature actually passed a statute criminalizing bringing in indigent people into California, and indigent people are poor people. And it led directly to the Supreme Court case, Edwards v. California, which we'll discuss below. And the response definitely had, it was a mix of economic fears, class anxieties, and sometimes concerns about preserving white native identity, which historically has been traced by scholars to like intra-racial exclusion meant to privilege local Californians and maintain social boundaries. Because essentially you had whites in California that were seeking to exclude these other whites from, other states, and they were somewhat otherizing white people. And also, and it's just an interesting intra-racial dynamic, right? And that happens in all racial and ethnic groups. I've seen it in all kinds of situations. But here's an example of, I guess, whites doing it. And also it was like white and blonde. And I know it's kind of weird because I'm white and blonde in California. And so I'm reading this and I'm like, I don't know if that's so good, but that it's not a good history. You don't exclude people and otherize them in such a way. But let's go ahead and do this. Let's jump into the questions presented by this case. Can a state lawfully impose a tariff, special tax, or penalty based on a new resident's origin? What constitutional doctrines in Supreme Court cases govern such attempts? Are laws excluding or penalizing migrants, like Abbott's proposal or California's Okie law, constitutional in today in light of history? Well, let's go ahead and jump into the discussion and the analysis. So first things first, let's break down the constitutional framework. Well, the first clause we need to deal with is the Privileges and Immunities Clause. The Privileges and Immunities Clause is found in Article 4, Section 2 of the United States Constitution. It bars states from treating citizens of other states differently. It safeguards free migration and equal residency for all Americans. So, one American can move from Tennessee to California, such as I did, or Tennessee to New Jersey at one point, as I did, or you can move from Montana to Washington, from Washington to Texas, from Texas to Oklahoma, from Oklahoma to Maine. And so you name it. Basically, you have, an equal right to all citizens to move freely, and a state cannot impose legal obligations to prevent you from doing so. And they must treat you equally as they do their own residents. So I would argue here that obviously California's Okie law was not, treating people well. And we're going to jump into that in Edwards v. California below. So I don't want to jump too much into it. But zeroing back to Governor Abbott's law and with respect to this statute, I would argue that Governor Abbott, by imposing a 100% tariff on, New York City individuals fleeing to the state of Texas would be treating these Americans differently. And, these Americans deserve equal residency rights, and they're entitled to free migration between the states. And that's a right afforded by the Privileges and Immunities Clause, which is, again, Article 4, Section 2 of the United States Constitution. So moving on, the next clause is going to be the Commerce Clause. The Commerce Clause is Article 1, Section 8 of the United States Constitution, and it provides that states cannot regulate or burden interstate commerce, including the movement of people. Now, we'll break down some cases below and how it analyzes that with the Commerce Clause and the Privileges and Immunities Clause, because, again, as I mentioned, in our nation's history, we have had, governors that have tried to implement laws to discriminate against, people moving from state to state, and those have been struck down under both the Privileges and Immunities Clause and the Commerce Clause. So it's important to keep both of those statutes in mind whenever we're trying to challenge a governor's law that would burden the free movement of people within our nation, and those people being Americans. So here I would argue that, where Governor Abbott does seek to impose a 100% tariff upon individuals fleeing New York City as a result of Zohran Mamdani's election, what he's trying to do is burden interstate commerce. And it's not that it's intentional. I mean, here I would argue it's definitely intentional. But even if he argues that the intent's not intentional, you're not permitted to do it even negligently. And so with that, Governor Abbott's 100% tariff law would effectively function as a burden on interstate commerce, and prohibit, the flow of money in that way. However, not only is it a burden on interstate commerce, another aspect is it does regulate interstate commerce, because when we're dealing with people moving, that's going to be, the free flow of movement, goods, and people, from state to state. And I would argue maybe like the good being, I don't know, a truck, right? Like we can make up a lot of different things. But anything that regulates interstate commerce or the interstate movement of people and goods and things of that nature, the channels of movement, only Congress can regulate that, not a state. If a state tries to regulate that, the state's law is going to be struck down, because, again, that is an exclusive power of Congress provided by Article 1, Section 8 of the United States Constitution. So I would argue here that Governor Abbott's 100% tariff law, both as an attempt to regulate interstate commerce, through the movement of people, in addition, and the goods with that, in addition, it would impose a burden on interstate commerce. Now, we also have to touch on the 14th Amendment, which protects the fundamental right to interstate travel and equal protection. Obviously, the 14th Amendment was a Civil War amendment, and at that time, slaves were not permitted to engage in interstate travel, because if slaves had escaped to certain free states, they would be free from that point on. And so that right to interstate travel was codified in the 14th Amendment to ensure that all Americans, including the freed slaves, would be have the right to interstate travel and to travel freely and to be treated as Americans in all states. And also, the 14th Amendment provides for the Equal Protection Clause. So in addition to that free interstate movement, you were afforded equal protection in all the states along with that movement. And that's very important for protecting Americans' rights as they travel through any state or, even territory in the United States. So the 14th Amendment also, it makes it so that the states actually have to follow the, due process clause and all that, all the Bill of Rights, not all the Bill of Rights, but a majority of the billable rights are applicable to the states through the 14th Amendment. So, for example, we have the right to freedom of expression. If a state tried to infringe upon the freedom of expression, it would have to, a person challenging that state's law would have to cite the 14th Amendment, because the 14th Amendment incorporates the First Amendment and applies it to the states. And so if a litigant tried to challenge a state law, arguing that it infringes upon his freedom of speech or freedom of assembly, all these First Amendment protections, Second Amendment protections, you name it, if that individual litigant does not cite the 14th Amendment, well, technically that complaint is not properly drafted, and it should be amended to include a reference to the 14th Amendment to ensure that we have proper incorporation of whatever law we're seeking to uphold. And so here I would argue that, we're going to seek to apply the Privileges and Immunities Clause and seek to apply the Commerce Clause to the state of Texas with respect to the 100% tariff policy. So jumping in just to some Supreme Court case law. Well, the first case we need to discuss is Edwards v. California, which is a case that was decided in 1941. The facts of this case involved a California law which made it a misdemeanor to bring an indigent or poor person into the state of California. This man named Edwards, he was convicted for bringing his brother-in-law from the state of Texas. So ironically enough, we're talking about California discriminating against Texans, while Governor Abbott is a Texan discriminating against New York City folk. And so what did this holding provide? It struck down actually that law passed by California, the Okie law, and it struck it down under the Commerce Clause. In the actual decision, it was stated that a statute of California making it a misdemeanor for anyone knowingly to bring or assist in bringing into the state a non-resident indigent person held invalid as an unconstitutional burden on interstate commerce. So again, that was an unconstitutional burden on interstate commerce as we analyzed above. And so, what's the significance of this case? Well, the court also, through concurrence, affirmed a constitutional right to travel between the states. So no longer can any state set up these bomb blockades and try to prevent the movement of Americans into different states. We have a right to freedom of movement. We have a right to be treated equally, and as any other citizen and as any other resident. And so that's some of the foundational law for those first tenets. Moving on to the next case is a case called Shapiro v. Thompson, which was a case decided in 1969. The facts of this case involved multiple states, including Washington, D.C., and in this law, in all these states had actually passed a one-year residency requirement before extending welfare benefits. So an individual or a family had to live in the state for a total of 1 year before they would be eligible for welfare benefits. Well, this law was struck down by the United States Supreme Court, and it was stated that this law violated equal protection and the right to travel. In the decision, it was stated that freedom to travel throughout the United States has long been recognized as a basic right under the Constitution. And what's the significance of this case? States cannot deny public benefits, tax, or otherwise penalize new arrivals. And so when we're taking a case like Shapiro v. Thompson, trying to impose an economic burden such as a 100% tariff, I don't even know what a 100% tariff looks like. You're going to strip them of all their wealth, right? If you got like a guy who's a millionaire or a billionaire, as soon as he enters Texas, does the state get to take away all his money? Is that what the 100% tariff is? Enlighten me for anyone out there who is advising Governor Abbott of what he means by 100% tariff. However, clearly, whenever we're dealing with a policy such as a 100% tariff, it's going to definitely harm the freedom of travel, because people would not want to travel so freely if they were going to face, loss of significant economic losses, which, the government would impose, because it would again, people wouldn't want to travel. And that would be under Shapiro v. Thompson, a violation of a basic right under the United States Constitution. So the final case we'll discuss on this issue is Saenz v. Roe, which was actually a case decided in 1999. And the facts of this case involved California limited new resident welfare to the previous state's level for the first year. So, for example, if an individual from Tennessee made X amount, but in California they would be entitled to Y amount of welfare, let's say 1,000 to 2,000, whatever number you want to use. California basically stated, all right, if you just moved into our state, you have to live here for 1 year before you're entitled to full welfare benefits. We'll give you the your old welfare benefits and what you made in your old state, but not the full benefits. And in this, it was found to be a violation of the Privileges and Immunities Clause, and the court stated that the 14th Amendment protects the right to travel in 3 ways, including the rights of new citizens to be treated like long-time citizens of the state. What's the significance of this case? Well, it provides that states must treat new and long-term residents equally, no penalties for migration. And so, where California only tried to provide partial welfare benefits in the first year, this violates, the Privileges and Immunities Clause, and it encroaches in too much on the federally protected right of the freedom to travel. And so, again, California has been a state that's actually, been huge for purposes of American jurisprudential law in the context of privileges and immunity, commerce clause, and how those constitutional provisions apply to the states through the 14th Amendment. Well, what's some of the historical perspective and exclusion dynamics? Obviously, we discussed the California's Dust Bowl response, exemplified how states combine, economic, class, and racial anxieties when trying to exclude newcomers, newcoming Americans into their states. In this case, as we discussed in the Dust Bowl, the Okie law, it involved a nominally white population, which, again, it's white people discriminating against white people, and it's kind of an odd scenario, but people do that all the time. Like, there's actually a history of, some black Californians doing the same thing when referencing blacks from the South, like from Tennessee, where I'm from. And, I live in California, and quite frankly, when I meet new individuals, there still is that old social, oh, you must come from this type of culture, type of attitude with me. And it's like, dude, I know how to make an arepa and speak Spanish better than you. So cut the crap. I'm actually I feel like in some ways, very American, and I can move anywhere I want to according to the federal Constitution. But a lot of these state residents in California, I must admit, they do kind of want to see me as like this, oh, he's from Tennessee, kind of attitude. But if I tried to act like that with any other population, well, they would see me as bigoted because they hear my accent, and I'm not allowed to say bigoted things like that with my accent, right? Kind of hypocritical, if you ask me. Does that make sense? Does anyone object? Please object in the comments below if you do. And so again, when we're dealing with the state of California, the Supreme Court rejected a lot of their exclusionary efforts and affirmed the constitutional protections for all Americans, whether an American's moving for work, for survival, for political change, fleeing a natural disaster, you name it. An American can move from any state and is afforded that right under the United States Constitution, and no state can discriminate against newcoming and new arriving Americans from other states. That's very fundamental in our laws. And again, when we're applying this to Governor Abbott's tariff proposal, it would replicate a lot of these unconstitutional principles already struck down by the Supreme Court, as we've discussed. And such a law would be basically impermissible under the Privileges and Immunities Clause, the Commerce Clause, the 14th Amendment, and all the relevant case precedent that we discussed. So in conclusion, it's my opinion that Governor Abbott's 100% tariff proposal is unconstitutional. It mirrors the legal and social flaws and exclusionary laws such as California's Okie statute of the past or the partial welfare benefits. And history and law both prove that, efforts to deter, penalize, or exclude interstate migrants, regardless of the stated motive, cannot survive judicial scrutiny under the federal Constitution. What's the enduring message of all this? Well, every American has a constitutionally protected right to move, settle, and build a life anywhere in the country, free from state-imposed tariffs or discriminatory barriers. And so if you want to move anywhere in the United States, feel free to do so, because that's your right as an American, and that's afforded to us by the United States Constitution. If you like this video, please like and subscribe. I would very much appreciate it. It helps me to grow the popularity of this channel, and that's something I want to have happen, And other than that, I hope everybody has a wonderful Wednesday, and enjoy the rest of your day. And until the next video, thank you very much.